And lady, you're flirting with somebody who's an inmate. That means that you should not be flirting with people in the crowd. This is not a dating show.
None of my family here.
And there it is, the judge laying down the law early. Imagine logging into court on Zoom and treating it like Tinder. Spoiler alert, swiping right won't get you out of jail time.
Listen.
I need a new attorney.
Are you ready to listen?
Please.
Are you ready to listen? Attorney, this is your
It's
attorney.
been very rude, and I'm not gonna accept it.
All right, here's the thing.
I'm just trying to work my case.
Okay. I've been a defense attorney. I've been a prosecutor. In this court, listen, be quiet and listen, because if you don't listen, you're going to miss something. I require in this court that the state make an offer. Legally and ethically, once an offer has been made, your attorney must give you that offer. Whether or not you want to accept that offer or not is completely up to you. But your attorney has to present that offer to you. If you choose not to accept it, you can tell your attorney, no, I will not accept this offer, but ask the state to give me this. And then your attorney, which is called a counter offer. Then your attorney will go to the state and say, hey, my client said they'll accept this.
Notice how the defendant immediately demands a new attorney. Quick reminder, wanting a new lawyer and actually being entitled to one are two very different things. Judges don't just hand them out like free samples at Costco.
Offer, if the state doesn't decide to dismiss this case, your only other option in this court is going to be that it's going for jury trial. So counsel, have you received all the discovery in each of these cases?
We have the discovery judge. The only thing we do not have is an offer because Marcus was in charge of the case. We were here last week. He was going to contact the complainant with this, and I don't think that contact has been made. And so, because he's a habitual, we really want to talk to the complainant witness and see if we can get this resolved.
Now, what I can tell you is the state hasn't proved that this is habitual or not, but based upon what you're charged with and based upon my education, if the state were to prove up the habitual, your minimum sentence is 25 years in the prison. So no. Here's the thing. I'm not getting into facts with you. I'm just telling you what I see. Now, I'm not accepting.
This part is huge. 25 years minimum if the charges stick. That's not a negotiation starter. That's a wake-up call. Question for you. If you were facing that kind of time, would you risk trial or take a plea deal?
So when you ask for a judgment satisfied, I just want to let you know that if everything is proven, your minimum is 25 years. So you're talking judgment satisfied and minimum is 25 years. So there you go. We're going to come back on January 27th at 9 a.m.
Thank you, Judge. Maybe excuse me.
Yes. All right. Hello. Are your clients in the center?
He has been evaluated and he's found incompetent.
Okay.
So we have a hearing the 20th, the agreed incompetence hearing before Judge Brothers.
All right, Ms. Ferguson, on Mr. Reyes, can you reset this for 60 days?
I need a new attorney.
All right, I understand. Thank you for letting me know. And we'll look into that. And my understanding is that you have a...
This is my first time being in jail for a burglary.
Okay. All right. So here's the thing. All right. Everyone, could you please whisper? So, Mr. Reyes, I understand what you're saying, and I understand that you want a new attorney. But my understanding is that a doctor has seen you before I can even look into getting you a new attorney, because the doctor has made an evaluation. Your defense attorney is telling me that you have a hearing scheduled where that doctor will be present. When is that date, counsel?
On the 20th, Judge, next week.
All right. Oh, it's just the doctor who talked to you about any issues you may have, okay? You remember talking to a doctor? Okay. No, I understand. So what's going to end up happening is on April 20th, they're going to take you to a different court, and that'll be the court with Judge Carruthers. and then they'll have a hearing on what the doctor said his findings are, okay? And then after that, we'll address your issue with regards to a new attorney. But
No, I know my way home. I know my bus routes.
Mhm.
Last time I was
Here's where it gets tricky. The judge can't even move forward until mental competency is sorted out. Translation: the legal system hits pause until doctors decide if the defendant truly understands what's happening.
so what will end up happening, Mr. Reyes, is your attorney is telling me that that hearing is set actually on April 20th.
That's correct, Judge.
And so they already have you in the system for April 20th, which is next week.
they also said I qualified for lifetime recovery.
Okay. All right. So what we'll do is we'll bring you back after that date on April 20th. I can't do anything with your case until they actually have a hearing on that. All right. All right. Thank you, Mr. Reyes.
Okay, Judge, maybe excuse.
Just one moment.
Just for the record, I spoke to him. He doesn't want me to represent him. There's also what he was found incompetent at once, and then he went to the process of restoration. The process of restoration.
Do you think he's competent?
I can say that. So I filed a motion for that earlier today, but
So you don't think he's competent?
I can't tell because he doesn't talk to me.
I have my reasons. I have medical reports, and I can take medication, but right now I choose not to because I want to work. You know what I'm saying? I'm trying to get probation. I've been incarcerated this whole time, trying to stay positive.
All right. So let me explain something to you.
I just need.
All right. This is what I need you to do. I need you to listen to me clearly. Are you ready to listen?
I need a new attorney.
Are you ready to listen?
Please.
Are you ready to listen? All right, so listen to me clearly. When you have a criminal case, if someone thinks that you're incompetent, which means you do not understand what the nature of your charges or the consequences of your charges, what ends up happening is they file a motion asking for a doctor to evaluate you. The reason why that is done is because he's not a medical doctor, I'm not a medical doctor. So a doctor will come and interview you. If a doctor determines that you are not competent, which means you don't understand the consequences of entering a plea or the consequences of your charges, they will either try to restore you and release you from custody, or they will send you to the state hospital. If the charge that you are facing is considered a violent offense, then they will send you to the state hospital. Your attorney cannot do anything until competency is restored. Once competency is restored, what that means is you go see Judge Andrew Carruthers, because he's the criminal law magistrate. They will have a hearing saying that your competency is restored. Then what will end up happening is you will be brought back to this court. And what I can tell you is you should be speaking to your attorney, because your attorney is telling me, here's the thing, your attorney, here's the thing,
There's no
wait,
witness.
here's the thing, quiet. Whether you want to sign for it or not does not matter. And when I say it does not matter, it's because if you don't want to sign for it, then you'll get a jury trial. But if you don't speak